matter the agency. The opposite party has blocked the door. I cannot go to the top floor first.
What do you want? Upgradation?
No, it didn't appear clearly on the top floor.
No, it is appearing in the list. Inclusion.
Yes, only top.
So, Victor, please come on Monday. Inclusions, upgradations, please come on Monday. Please mention on Monday, because mentioning is only on Monday.
Lord, may I have
My
your
lord,
lordship's kind leave to, my lord, file an urgent revisional application without...
What is the urgency?
My lord, the arbitral award has been put into execution. My stay petition has been rejected. Lord, the order was uploaded only on Monday, my lord. We have already applied for the certified copy.
All right. Police help, 41. 41 টা 12 করে রাখুন তো। Who is any KVA?
yes,
Yes.
I am mentioning one matter, my lord. It is pending in the list, my lord. Item number 1756.
Upgradations.
No, my lord. It is yes.
Upgradation you want? Upgradation, please mention on Monday.
My lord, your lordship has already disposed
Please
of the
mention on Monday, sir. Upgradations, it's an indication in the list.
My lord,
Mentioning.
My lordship, there is no leave to file this with the certified copy, my lordship.
Why? What is the urgency?
My lordship, the next fixed in the trial is 24th, my lordship. For expert hearing of the suit.
Yes. What is the order you are challenging?
Challenging for amendment of the pen, my lordship.
Amendment of the plan rejected.
Rejected.
When the order was passed?
5th of August. 5th of August.
Have you applied for the certified copy?
5th of August.
Yes, you have not got.
No, my right.
All right. Yes.
My lord, am I permitted to praying for leave to file civil revision petition, as I am unable to collect the impugned order.
When the order was passed?
Order in the month of January, but kindly consider, my lord, my advocate record was
please
was
obtain the
very serious ill. He is admitted in the hospital.
Have you applied for the certified copy?
Yes.
When have you applied?
Applied in the month of this month. As because his father died, he also.
Yes. No, please file with the certified
Tomorrow
copy.
is the lordship. Tomorrow
number 132, 133. The writ of possession already issued without verifying the final decree. This is a partition.
132, 133 of the supplementary list.
Supplementary list.
132, 133, 12.
Lordship, item number 57 of my Lord's list. Lordship was hearing two connected.
Item number?
57 of my Lord's list.
Yes.
My Lord was hearing two connected civil divisional application, disposed of one and directed the other one to be listed today. Rather than the other one, the older one has been listed, which is already disposed of. CO2161 has been listed. CO2615 was directed to be listed.
এটা দেখে নিন তো কোনটা।
Item number 1.
Item number?
127.
Yes.
I am on expert. He appeared on 1st August. You have order for
No, just please let me proceed.
Lordship, I'm mentioning for upgradation, Lordship.
Upgradation, please, Monday.
Lordship,
Yes.
there's grave urgency that the
Maybe.
matter in
Please
lower
mention
court
on
is
Monday.
on 19th.
Please mention on Monday. Yes, next. Please call the list.
Non-prosecution.
What do you want? Non-prosecution?
Non-prosecution. Instruction is with the mentioning.
Where is the instruction?
With the mentioning
The line that
matter, I am for the petitioner.
yes. Yes, who has mentioned this?
Lordship, I have mentioned this for release because the lawyer of the other side is Mr. Shonak Bhattacharya. For that
Since I am
reason,
not inclined to take up this matter on personal ground, this matter stands released.
Three, my lord, I am for the petitioner.
Similar prayer for withdrawal, my lord, appealable order. My lord,
The learned advocate, what is the order?
Lord, it's a decree, my lord, under the preemption case, wrongly filed. Only one thing to save the face of my advocate on record. Kindly, my lord, writes, my lord, this is an appealable order. So, my lord, that is the only thing. Otherwise, he is facing a difficulty.
No, no, no.
And the certified copy, my lord, I should, my lord, take back upon the usual formalities. Dada, chota.
This case was dismissed as not maintainable.
Yes, yes.
After going
And I am for the petitioner. Lordship, there is only one correction. Kindly
one correction, what is the correction?
Lordship, there, September 15, it will be September 14 to 2026. Kindly comes to the para 1.
Yes. Submits the September 15 has been fixed. It's not September 15.
It is September
The
14.
learned
Your
advocate
Lordship.
appealing for
In the ordering portion, my lord, the suit number to be corrected, suit number 6, it has been.
suit number.
Yes.
What should be the suit number?
673.
673. It has been pointed out.
They are appearing for the opposite party, will appear.
Your Lordship, on the last occasion, Your Lordship.
So this is an application for extension of the interim order, my lord, or reimposition. I'm
Appearing for the petition.
Extension of interim order.
Yes, your Lordship.
No, no, no. Oh, really? Yes. Since I'm not inclined. Yes, Mr. Mondol, please serve a copy.
My lord, before my lord takes up the next matter, my lord, may I be permitted to mention one matter, my lord?
No, no, not.
My lord,
Don't
my interim
mention
order
now.
has expired, my lord.
Yes.
I missed the bus, my lord. I was
Not now, please. Yes.
This is my application, my lord, item number 7. For extension, really reimposition of interim order, my lord. Since state is the party, lordship directed us to serve again. We have done that, my lord.
Government period you have served.
Yes, my lord.
Nobody is appearing.
Lord.
Can is for extension.
Can is for extension.
তাহলে এই উপরে লিখে দেবেন can ওইটা is for extension after hearing.
Great.
Yes.
I got the opposite party number 1.
Praying for extension of interim order lawsuit and fixing the date of hearing, fixing the any date.
Upon hearing the learned advocates for
Nine, my lord, I beg to appear for the petitioner.
what is the can for? Can is for extension.
Extension.
But I'm for the opposite party, matter can be
Well,
disposed of.
It can
Here
be
and now.
disposed of.
Disposed of.
Well, kindly see the
Can
impugnment,
be disposed of.
No, no, my lord.
No, no, my lord.
Main petition I also prayed for disposed of.
because
What
they have challenged. They are their DW was struck down by the order impugned. They have given 3 times.
My lord, I got
DW was closed.
Yeah.
Let it
challenge.
be allowed and let the suit be disposed of within certain period. Because it's an argument
My
stage.
prayer is that, my lord,
It's an argument stage has been designated as fixed for argument. And since there is an interim order,
Depends.
what has happened, my lord, I got 2 dates. Now, from the first date, the learned trial court fixed it as a last chance, and then a special chance given, then my defense got stuck off. My lord, all I am praying is that let me, my lord, adduce evidence and matter would proceed in accordance with the law. My lord, kindly take the order dated, my lord, my lord, 13/12/2025,
13th,
12/2025. Over
13th
there,
or 16th.
16th of
my
December.
lord, kindly take 3rd December 2025.
3rd December.
On that day, my lord, I filed an order 6, my lord, order 7, rule 11 that got rejected with cost. Then on that day, defense witness chance was given as a last chance. Kindly take the order.
Matrimonial suit.
Matrimonial.
Section 9.
But what happened, Lord, may I say, my application under Section 9 is pending in West Bengal. Their suit is pending in Uttarakhand. Taking fee that they
not
will state,
Uttarakhand, my lord, Uttar Pradesh.
Uttar Pradesh, whatever.
Not Uttar.
But their divorce suit is going on. My suit is state.
Ashwin.
But
Well,
let
I
them
filed
pay
my-
some cost.
Why? I paid, my lord, 20,000.
Maybe.
Well, initially I paid. I am paying the maintenance even.
Maybe.
Well, what cost?
Unless no. Then no. So many chances were given.
Well, not so many chances. My lord,
You are
then
so adamant. No.
my lord, then
It's not a matter of right.
my lord, then I place my case, my lord.
Yes,
Kindly
yes,
see,
place your case.
my lord, if my senior is asking for cost, kindly take the order which is passed by
He's
this.
not entitled to cost.
My lord,
Please
he
show
is,
me your conduct.
my lord,
Please give me a
my lord-
list of dates. How many dates you have taken adjournment?
my lord, 2 dates. On one is for my medical point. I place the medical report because, my lord, I am a,
Show me the medical prescription. Let me see.
my lord. Page 65, my lord.
Yes.
Because, my lord, I am a army personnel,
Maybe.
the Air Force official posted in Coimbatore. I was admitted therein. And from my commanding officer, my lord, through commanding officer,
In your suit also, you are taking time on the ground of medical grounds.
my lord, they are taking time.
No, they will be taking time. I'm asking you, are you taking time
Well,
in your suit?
That my
Please
suit,
produce the order sheets
Well,
in that suit.
my
Let
lord,
me
my
see.
suit also need not being proceeded because as pendency of these
No, that's a different thing altogether. How many adjournments have you taken on medical grounds in that suit? Let me see.
that in that suit, my lord, I am not asking for any adjournment
I-
because they are
that-
asking to adjourn.
That much I have appreciated. I'm asking you to see your conduct in that
My
suit.
lord, then I have to take all order sheets from therein because they are asking
If
kind
you be
of.
trying to delay.
No, my lord,
uh,
not delay, my lord. Kindly see order 3 order, my lord. I will.
Yes,
Order
yes,
number-
from the medical prescription, what do you want to show?
DW
on
fixed
that,
on
my-
30th
Sir,
June
let me-
2025.
My lord, let me first place my case.
Yes.
My lord, on that medical ground, I sought an adjournment on 9/12. Date was given on 16/12. On the 16/12, my defense got started.
This discharged on 16th of December.
Yes, on that day when with that medical, when I prayed for adjournment, the learned trial court recorded no medical was produced, hence my DW got closed.
Then,
But my lord, I have that medical, I produce it before the court below.
then go there, file an application for review. If you say that yes, you have produced there, court
My lord,
not
I can't,
consider,
my lord, I
your
can't,
remedy is not revision.
no,
Your
my lord,
remedy is
I can't, my
review.
lord, I can't say that. My lord, all I am saying is that I want to adduce an evidence. My lord, the suit is not being dragged by me because they produced 3 witnesses. Then I got 2 chances. On the day when my order 7 rule 11 got
That's
rejected.
not your right that you are
My
entitled
lord,
to.
I am not asking. My lord, in order 7 rule 11, 20,000 cost was imposed. My lord, I paid that cost.
This shows your intention to delay the
My
proceeding.
lord, I am not at all intended to delay.
After filing the written statement, you have filed order 7 rule 11.
Well,
This shows your intention.
Well,
What was the ground in order 7 rule 11?
Well, order 7 rule 11 ground is that I filed divorce over there, and then after they
That's order
filed
7
section,
rule 11.
well, that is pleaded in that application.
That is what I am asking you.
Because
filed-
otherwise, my lord, the
So you wanted to drag this proceedings
my lord,
by
I'm
filing
not,
frivolous
my lord, kindly fix it 6 months, my lord, let the
6 months.
my lord, I don't know, my lord,
But kindly see
got
page
instruction or not.
77 one.
As far as I got instruction, the present trial code is vacant. If charge code is, my lord, is taking up the matter, I am ready to dispose it of within 3 months even.
But kindly
But
see
I
page
paid the
77 one. Page 77.
My lord, kindly see.
Page 77.
Yes.
Order number 16. Today is fixed for cross-examination of PW1. PW1 was present for cross-examine. None appear for the defendant. No cross-examine. Cross-examine closed. Well, kindly see. Discharge uncrossed examine.
If my lord
Let
kindly call
the
for the
cause
lower
for
court
DW
records, my
on
lord
14/7.
be
But kindly see
my
14/7.
lord will get to know
30th
how that.
June 2025, a date was fixed for DW as the
DW.
last chance.
Then argument. Then my lord,
Yes.
my
So
lord, kindly see the last
so
line.
prior to that,
No,
you
no,
might have.
kindly take
Let
the
me see
my
the
lord,
previous
kindly
order.
take the previous one order. Both the parties are present by filing
Non-appearance of the
the respondent, hence the case is
respondent
adjourned
14th of May
for
2025.
cross-examination of PW1.
Whatever it is, you did not appear on that date. Cross-examination was also adjourned. This is your conduct.
My lord, then subsequently, my lord, kindly see, my lord, the DW, my lord, is given only 2 dates. Kindly consider that aspect. And it not even the case that I didn't pay cost. The Honorable Justice Sampa Sarkar, my lord, directed that I have to pay 20,000. I paid that. In my CAN application, I annexed that document.
Can 1 of 2026
They have to pay cost for my 7-Eleven, rejection of 7-Eleven.
Yes, call the next
Right.
matter.
Much obliged.
Wait, application disposed of.
Can also dispose.
Yes, Mr. Swami.
From the affidavit service lordship, due to addressee was absent lordship, for inquiry the track report is showing the addressee was absent at the time of delivery lordship. It's a
The
Inter-modal lordship. Inter-modal extended up to lordship. Inter-modal extended up to lordship.
December.
Lord, the order under challenge, Lord, under section first under section 10 of the CPC, my Lord. The order impugned.
Can I take up this matter? Have you checked up? I can take up. Who are the advocates appearing in the trial court?
Lord, trial court, my Lord.
Please ascertain, come back. I'm making it not today.
Lord, for the plaintiff.
Both, plaintiff, defendant, both.
Ashish Bhattacharya for the Ashish Bhattacharya for the defendant in the trial court.
And plaintiff?
Goswami. Goswami.
Aurobindo Goswami? Yes.
Lord, the order impugned, Lord, is passed under section 10 of the Lord CPC. Passed under section CPC, under challenge, Lord, under CPC, Lord, passed under section 10 of the.
Hey, there are two suits.
Two suits are there.
Yes, one filed by you.
One filed by me. Lord, in that suit, Lord, only one defendant.
What is the nature of the suit that you have filed?
Lord, I have filed suit for partition and injunction.
You filed for partition and injunction?
Lord, they have filed, Lord, declaration and injunction. Lord, they are telling, they are saying that they are the sole owner of the suit property. Lord, I am saying that, Lord, I have got them, Lord, deed of gift. By way, Lord, I have got them, Lord, mutated in the Lord record of rights. Lord, I am enjoying the same, and they are saying that, Lord, what happened? Lord, I have got them, Lord, property from my Lord maternal aunt, one of my maternal aunt. Lord, by deed of
by inheritance.
No, Lord, by deed of gift.
By deed of gift.
Deed of gift is there, Lord. Deed of gift I have annexed.
Please give me a minute.
Lord, that Lord, I have got it mutated. Lord, they are saying that they are the sole owner because they are denying the same, but they have not challenged the Lord said deed of gift. In their suit, Lord, two defendants are there. In my suit, only one defendant. Show me, Lord.
Yes, rightly so. The subsequent suit is dependent on the first suit.
Lord,
if that suit succeeds, nothing remains in your suit. because it cannot be said to be a joint property.
Deed of gift is there. That is no challenge. So, in their suit, two defendants are there. Not
Let
only.
both, because if they succeed in the first suit, the suit for partition
Kindly
goes then.
kindly see the order, my lord, order implement, my lord. The order implement says that upon perusal of the materials and records, upon hearing of the learned advocate for the both parties, it appears that both suits are between the same parties. That is the same parties. Because in their suits, two defendants are there. In my suit, only one defendant.
That neither here nor there. The scope, both the suit property is the same.
Suit property is the same.
Now, please here, if the suit property is the same, their suit is for declaration that they are the absolute owner.
Absolute owner.
So if they are the absolute owner, if that is declared, what remains in your suit, more so it's a subsequent suit.
What is they are done, my lord? They are filed an application, my lord, for hearing both the suits. They have filed an application. I it's the same. And they are.
What are the stages of both the suits?
My lord,
what is the stage of the first suit? What is the stage of your suit?
My lord, no issues have yet been framed, my lord. No issues have yet been framed.
What is the stage I am asking you?
My lord, stage, my lord.
Your suit is 558 of 2021.
My lord, 555 or 2021.
Yes, and where is their plaint?
My lord, their plaint, my lord, is my lord, page 56.
Page
56, my lord. Suit for declaration and injunction, my lord. And then both, my lord, two defendants are there. And they have also filed written statement. I have also filed written statement. My lord, that statement, my lord, award. They have filed 3 applications in my suit.
How it is? If the first suit is decided, that issue will be res judicata.
My lord, they have not yet challenged the deed of gift. My lord, that is still existing. The deed of gift, they have denied the same. They are not, my lord, admitting the same. Deed of gift is with me. In that, my lord, on that view, my lord, on that basis, my lord, record order has been corrected. I have annexed the same. My
Deed
lord,
of gift by whom?
my lord, by my maternal aunt.
What is the name of?
My lord, name, my lord, I have annexed, my lord, deed of gift. That is, my lord, page 39, my lord. 39, my lord. My lord, Data, my lord, Srimati Suchitra Mukherjee. And my lord, I am, my lord, Himadri Chatterjee. My lord, due to, my lord, disturbance in the family, my lord, Shiva Jogi Tash, my lord,
Senior standing. 12, I am for the petitioner, my lord.
My lord, I am for the opposite party. I have the instruction to appear, my lord. If a copy may be given.
My lord,
Mr. Bhattacharya, you are for the petitioner.
yes, my lord.
Yes.
No, my lord, here, my lord, I am only seeking a direction to take up my application. What happened, my lord, that
I am a
What
lessee
application?
under
What application?
my application for extension of interior order. My lord, very interesting matter, my lord, that I am a lessee and eviction
Yes,
order
Mr.
was.
Nag. Extension of interim order application, let it be taken up.
Yes, that is why innocuous prayer.
Before whom? I don't know. I do not have any copy of this.
Give him a copy.
My lord, what happened, my lord? I am a lessee and eviction order was passed against me, challenging that an appeal was preferred. Now, my lord, in the said appeal, there was a direction to pay rupees 1 lakh, my lord, as a lump sum amount, and my lord, the London district judge was pleased to pass an interim order. Now, my lord, if your lordship kindly turn to the
Then
order.
what happened? Then
Yes,
what
my-
happened?
Then, my lord, I have deposited 1 lakh rupees. Now, my lord, on the date fixed, I made an application for extension of interim order. That application neither disposed of nor rejected nor allowed. That is still pending. On the contrary, my lord, they have filed an application for vacating of the interim order that was considered and disposed of. And my lord, the court proceeded, my lord, the next date fixed for hearing of the appeal. But till date, my application for extension of interim order is still pending. If your lordship kindly come to the order dated, my lord, first order is dated 12th of November 2025, wherein, my lord, a direction was given, my lord, an interim order was passed, and, my lord, kindly come to the 7th of April 2026 order. 7th April, my lord.
Please give me a minute. Yes, Mr. Nag, what do you say?
But after 7th April 2026, there are two orders.
Yes.
But they should have pressed for the disposal of the application. On the contrary, they have prayed for adjournment.
You don't want money, it seems, Mr. Nag. Money you don't want.
Money. Money.
Yes, condition for stay.
But that was deposited.
Yes, that was for 1 month, Mr. Bhattacharya.
My lord, rupees 1 lakh, my lord, from 7th of April's order, lordship
Yes.
find that I have deposited the order complied
That
with
was
the
for
order.
1 month.
Yes,
Mr.
yes.
So that is what I am asking you, asking Mr. Nag, whether he wants the further amount or he is satisfied with 1 month. If you are satisfied with 1 month, then I am extending the stay without any condition.
No.
Then,
Not at all. Not at all.
no.
Well,
Then I am directing the stay application to be decided.
I am saying, my lord, lordship, my lord, subject to lordship's kindly fix a date for conclusion of hearing of the appeal. And in the meantime, whatever they are supposed to pay, they should clear up the outstanding.
What outstanding? There is no outstanding.
They have paid only for 1 month.
Yes, but order was for 1 month. Thereafter, stay application. If you say I can direct the appeal to be disposed of, I will extend the order of stay. And if you want, I can direct the stay application. You say 1 lakh, 2 lakh, 5 lakh. That option will be there.
Well, I have to take instruction. What is the due as of today? If lordship takes up,
The due is also take that in the stay application. I'm directing the stay application to be disposed of. That's pending. Take all points there. Whatever whatever amount you want, areas, everything. Take that because the stay application has not been disposed of.
correct, but stay application, well, the appeal has been fixed. Well, the appeal can be disposed of.
Then I'm directing. I'm fixing the
Last
expedition.
minute, I can come back with the amount so that they.
No, not on that. I will not direct them to pay here and now on that instructions. Then go there, raise all points because those are to be considered. revisional code for the first time, I will not consider what the areas.
Lordship,
If
then
you want that, I will direct the stay appeal. If you say you want interested in the hearing of the appeal, then I will say
the
that
hearing of the appeal is better.
then if you
Well,
cannot
stay will
execute
go on
that.
for another 1 year.
So then
At a
I
time
will
bound
extend
order.
the stay for the
Time
till
bound
the
order.
till the disposal of the appeal.
Time bound order for disposal of one. Well, that.
Yes, Mr. Vadayaji, what do you
Yes,
say?
yes, my lord, yes.
Now
I'm
you are
agree.
happy. You don't have to pay, you are happy now. Application under Article 227.
Lordship, please to extend, my lord, give a direction to dispose of the appeal, my lord.
No, Mr. Bhattacharya, I have directed the stay application because Mr. Nag, he told once, then while I was recording, he says he cannot undertake that. Then the stay application is to be heard.
Without any
Lordship.
written instruction, I cannot give any concession.
Lordship.
Yes. If that cannot be done, Mr. Nag, why are you making those submissions then? You have to take some responsibility. Yes. Yes, Mr. Mukherjee.
My lord, I'm making a bit adventurous, my lord, argument before your lordship, my lord. I was belated in filing an application under 7.1. That is belated, my lord, by
7th
7.
allowed.
Yes. But only point that I urge before your lordship, my lord, in this matter, it so happened, my lord, that there was an undervaluation of the suit. That one suit was filed, my lord, comprising 2 tenancies. The rent, my lord, that was stated to be, my lord, the valuation of the suit, my lord, was stated to be undervalued. I took out an application under Order 7, Rule 11 to say that the plaint should be rejected because of the undervaluation. But the court upheld and said that yes, the suit is undervalued and therefore not required the plaintiff to put in the balance of the court fees. Now, my lord, if that is taken into consideration, my lord, I am not belated. Why I say this, my lord? According to my client, my lord, when he took out an application, he said that he received the summons on 11th of March 2020.
But Mr. Mukherjee, only one thing. Section 7 uses the expression, if a suit is filed
I understand.
and summons served and the time limit from the date of service of summons or from the date of appearance, whatever might be. Order 7, Rule 11, directing them because the plaint is not rejected.
Plaint is not rejected.
Not rejected. On that application, they were only directed to put in the deficit court fees to correct the valuation and to put the deficit court fees.
Yes, but Lord, can it
that
be
does
said?
not stop you from performing your obligations under Section 7.1 because the suit was pending all along.
Lord, I bow down to your lordship, but one way, Lord, just I am trying to, Lord, put before your lordship is, Lord, that since, Lord, the suit was undervalued and the court fee was not paid, Lord, the summons that was served, Lord, pursuant to the undervalued suit, Lord, could be said to be a valid service of summons. If not, then, Lord, my first date of appearance is 20th of April, on which, Lord, I filed the application, squarely falling within, Lord, that 1 month of appearance.
Summons cannot be said to be, even if a suit is undervalued, because Mr. Mukherjee, Order 7, you will be finding 2 things. If a suit is undervalued, plaint cannot be rejected. Your argument would have hold good if the statute said, yes, undervaluation, court finds, reject the plaint, no option. But here it says, once you 2 stages. So if you, that's not the stage under Order 7 so fast, direction is to be passed to do that. If that is done, then
that has been done. I cannot contradict.
So if that is done, plaint is also not rejected.
No.
Then you cannot say that the summons is irregular, or you cannot say that. Because if Order 7 court does not, the statute does not empower to reject even for undervaluation or deficit in court fees, can that be taken up?
That is the only point, Lord, I had. Other thing is that, the 7.3 was allowed suo motu by the learned judge without an application by the defendant. That is also not permissible under the statute. But I rest my case, Lord. I don't have much, Lord, to accepting that point.
You raised this point before the trial court? No.
I took this point before the trial court. Trial court, by a very cryptic order, Lord, rejected my contention.
What is the reasoning of the trial court?
The reasoning of the trial court is based upon the Supreme Court and the Calcutta High Court judgment. But
no, with regard to this, please show me that you have raised Order 711.
Yes.
That part, where is that? And
that I have taken in 151 application. Milord, that 151.
No, but 151 was subsequent.
So in connection with, Milord, this application under 7172.
151 was considered by this impugned order.
Yes.
Please show me that portion.
That is a very cryptic order, Milord. That portion. Your Lordship will kindly come to the impugned order. Lord, your Lordship will kindly come to, Lord, that in respect of, that is an internal
the point was taken note of.
Yes, it is pertinent to mention here that on payment of the court fees being paid. that portion পাতার নাম্বারও দেয় না কেন বলতো না তুই দিতে পারবি না ওটা ট্রায়াল কোর্টের ট্রায়াল
Mr. Mukherjee is there, but in a different way from that, I was observing. Is there in that respect? This is penultimate page, last paragraph. Previous paragraph records your submission.
Yes.
In that respect, it is pertinent to mention that on payment of the court fees being made, being paid after direction, the plaint is deemed to have been filed presented before from the initial instance in a roundabout way, but the effect will remain because
that is the reason, my lord, I can't argue with much force, my lord, because of the word used, that service of summons.
Service of summons, and you could not have also argued, may not have also argued that there was no institution of the suit as on that date, because that also could have taken care of your submission, because institution was there. Institution cannot also be said to be bad.
Maybe a
because
irregular
that reasoning has been given, because institution cannot be said to, though in a different form, institution, because let me see order 711 once. The language is, I think, your case is order 7 rule 11B, where the relief claimed is undervalued and the plaintiff on being required by the court to correct the valuation within a time to be fixed by the court fails to do so. So
In
this
that-
is one. And second is where the relief claimed is properly valued, but the plaint is written upon, it's not, C does not come. So in your case, even incorrect valuation is not a ground under order 711. Point raised was a arguable point, Mr. Mukherjee,
But
but
I
no
understand
use
what
in
this was,
keeping this pending. Ashun.
149 of the CPC, my lord, it says that it goes back, my lord, to the date of filing of the suit. Yeah, on that logic, even, my lord, I cannot fit it into this. The last line of 149.
That is deficit court fees.
That is.
Here in your case
The-
is undervaluation.
And effect is as such fee has been paid on the first instance.
I think it's also
ban.
একটা প্যারাগ্রাফ একটু অ্যাড করে নিন তো রাইডার বলে ঢুকিয়ে দেবো at this stage it will be relevant yes.
My lord, I am for the petitioner, my lord. Prayer for early disposal of the title suit, my lord. My lord, the plaintiff respondent herein.
Who are you? Plaintiff?
I am the petitioner herein.
Defendant.
Before the learned court below, I am the principal defendant. I have filed this revisional application.
Yes, what is the impugned order?
Kindly see, my lord, page.
What is the nature of the impugned order?
My lord, they have digging the said title suit by taking unnecessary adjournment, my lord.
Expeditious hearing?
Yes, my lord, expeditious hearing.
PW2?
Yes, PW2.
What is the next date fixed for PW2?
Today is the date fixed for PW.
PW2?
Yes, my lord. Before the learned court. Let a direction be given upon the learned court below. For
now good to see that the defendants also want expeditious hearing of suits. So it's good that the proceedings will be expedited. This application under Article 2. Yes, call the next matter.
Lordship, there is an application for expeditious disposal. The petitioner before your Lordship is the wife.
Petitioner is the wife.
Lordship, the wife have filed one recalling application.
Filed one?
Recalling application.
Recalling of what?
Recalling, Lordship, Order 9, Rule 13, recalling of that matrimonial suit order.
Ex parte, suit decreed ex parte.
Lordship, the suit had decreed ex parte.
Service is not complete in the miscellaneous case.
Lordship, the service has been affected. The husband had appeared the last occasion. Next date is fixed before the learned trial court on 3rd of December 2026.
Now he has appeared.
Lordship, the last occasion only the husband had appeared. The wife's evidence has been completed. I am before your Lordship only for expedite the miss case.
Wife's evidence completed.
Lordship,
When it was concluded.
Lordship,
This application under Article 227
There is no caveat, madam, before your lordship takes up the matter, madam. Your lordship kindly simply order if you possible that is not legible. That is not legible.
The impugned order is not legible.
Legible, my lord, your lordship can see, I could not decipher anything from it, but therefore, my lord,
But Mr. Ghosh, have you checked up? It's right.
yes, yes, I have checked it out. My lord,
Yes, what is the issue? What are you?
issue before your lordship, I am the judgment debtor in a suit for declaration of title and eviction. My lord, the suit property belonged to the defendant. There was an agreement for sale. After the agreement sold, he defaulted in executing the decree. A suit has been filed.
Please use the microphone.
A suit has been filed for recovery of possession. I become a licensee. Expertise degree was passed. Given the expertise degree, my client has filed an application under section 47. 47 would has been registered as jury.
Expertise degree, so you have not challenged that.
It has not been challenged, but what can be done when I got the brief? I thought, my lord.
All right, so you have accepted the expertise degree, then
Yes, expertise degree has filed, my lord. Against that, a revision has been filed. Revision has been admitted, but court refused stay. That is the last order, your lordship.
Then what happened? What is this?
Thereafter, my lord, execution case has been levied. In the execution case, my lord, the bailiff has given a report that there was a resistance. Without filing any application, order 20 rule 97, my lord, without any inquiry, police help has been granted. My lord, your lordship kindly sees the last portion. Although the last portion of the order, the court says there should be an inquiry under order 21 rule 98 sub rule 2. But without any inquiry on unverified statement of the bailiff, my lord, the police help has been granted. And my lord, I say, my lord, this is absolutely contrary to law, my lord. I have a judgment, the 2025-9 SEC, which has been referred, my lord. Paragraph 52, it has been stated. The inquiry has to be made under order 20. But this is the harshest of step for passing an order of police help in granting degree. And there was no application filed on behalf of the
208 can be done.
Nothing has been filed. No application filed. I would have understood, my lord, and application order 20 and has been filed. 208 has been filed. Suo motu the court directed police help. That is contrary to law, my lord. If your lordship kindly comes, my lord, last paragraph, though the decree holder has not filed any application for police help in compliance of the direction of the Honorable Supreme Court in case of Rahul S. Shah. My lord, this Rahul S. Shah judgment has been, I brought this judgment. No word is stated.
What can be done? You have seen those directions contained in those two decisions.
My lord, decisions.
What can be done?
The earlier judgments, my lord, I brought, my lord, one judgment, your lordship appeared. One judgment to Gopi Krishna Maji's case, your lordship knows the judgment. The court says, all the stalwarts appear, Mr. Mukherjee and Mr. Raichuri. My lord, this type of cases, my lord, without any application, the police help cannot be granted. My lord, inquiry has to be made under order 21 rule 90 sub rule 2. My lord, your lordship knows better than me. Therefore, my lord, let the application for
what can be done? Have you seen the directions in 2025?
Yes, I have seen, my lord, kindly see paragraph 54. The court says the inquiry has to be made. 52, 54. For your lordship. My humble prayer is there is no application even. And here, my lord, it has been stated an application has to be filed for resorting to the relief of police help. In this particular case, my lord, there is no application filed. Court says since the bailiff has said there is a resistance, therefore police help has been granted. Paragraph 52, 54, my lord, you kindly see. Those court says order 21 rule 92 sub rule 2 has to be resorted to while granting police help.
Mr. Ghosh, learned advocate appearing for the petitioner may be justified in দিয়ে দিন একটা উপরে করে দিন line this matter was mentioned by Mr. Yes.
2579, my lord, CO.
Yes.
My lord, last page, my lord, the last page of this, my lord, directed to ministerial staff to the court to verify the draft of the writ and submitted by the decree holder to examine correctness. It is reported in writing that the draft writ is without any error and there is no stay order on the date. My lord, this order was passed on, my lord, on 27th July 2026. My lord, kindly, my lord, page 23. My lord, page 23, my lord, I file an application to supply, my lord, the certified copy of the judgment, preliminary decree, final decree, commissioner's report, and my lord, the sketch map. My lord, then, my lord, next page. My lord, the department. Page 23.
No, what is your challenge?
My lord, challenge, my lord, kindly see, my lord, page, the next page, my lord. The court, my lord, informed that the application of such and such is pending as the instant disposal record being has not been found. My lord, same date, court says that this document is not found, and my lord, then my lord, they verified the writ. My lord, without sketch map, without, my lord, the final decree, my lord, writ issued. But this is a partition suit, my lord. This is a
Yes.
My lord, kindly see, my lord. My lord, the execution, when the execution was filed, my lord, I do not know, my lord, whether, my lord, the case record was actually there or not, my lord. My lord, when the execution was filed, the certified copy was filed along with the tabular statement, my lord. Upon going through the certified copy, my lord, the court can, my lord, do this, my lord. My lord, only one thing, my lord, kindly see what they have done. 1979 suit, appeal
No, but
dismissed.
can you support the finding at paragraph 12? Until the third party judgment data loses their possession.
That they have not challenged. That they have not challenged. That portion they have not challenged.
Yes, 27th of July they have challenged.
No, my lord, that portion, that is not, this application is not there, my lord. They are not challenging this. They are challenging the second portion, latter portion, my lord. Kindly see, after the ordering portion, latter, a report in writing, my lord.
No, they have challenged the entirety of the order.
They can't, my lord. Kindly see, my lord, whose application was that? They are not the petitioners over there.
Kindly see, my
They are
lord.
not petitioners in order 21 rule 99.
No,
we-
Khokon Bauri
But
was
with the
one of the-
judgment data, my lord. With the judgment data. Judgment data, my lord.
one Khokon Bauri has filed that application. That they have not challenged. They cannot challenge that.
Where is the order 21 rule 99 application?
My lord, they have not annexed that.
Where is that application?
That applications.
Well, 70% of the
My challenge is only that portion, my lord, the
Which portion?
the issuance of writ without verifying, my lord, that this is a partition suit, my lord, this is a partition suit, my lord, the sketch map, and my lord, the final decree is necessary. My lord, without my lord going, my lord, verifying, my lord, the sketch map, and my lord, the how my lord, the writ be issued. My lord, they specifically says, my lord, the court that this is the record is not found in the. Kindly see, my lord, there's a finding of the information. Record being Atho has not been found in record. In record yet. This record is not found, discovered yet. My lord, page 24, my lord, there's information slip. My lord, kindly see.
Page?
Page, my lord, 24, my lord, the 23, then my next page, my lord, the information. On the same date, 27th July, the application of such and such is pending as the instant disposal record being titled such and such has not been found, discovered yet.
Yes, what do you say? If the records are not traceable, how can this be?
kindly consider the judgment, my lord, judgment decree and the my lord, commissioner's report are necessary.
Nothing is record on application. Please see 24.
My lord, kindly see, my lord, 24, my lord, this information slip, my lord, whether, my lord, the record was there or not, my lord, that has not been recorded in
That
the
is the court's information slip.
only the information slip with
So if those are not produced, how can the read be
My lord,
verified?
it is the information slip is only in respect of the application, my lord, of the certified copy. Now, my lord, what happened, my lord, with the
Application of the
certified copy? This is the certified copy application. Why it has not been processed? That is only the information. Kindly see the application dated so and so is pending. The application of my learned friend for certified copy.
yes, yes. This is certified copy of the document that is pending. It's not that the records were not there.
No, no, if, why the certified copy has not supplied? Only that ground, the record
That's
is not.
where have you stated that the certified copy was not filed? Please show me.
Yes,
Please show me in your pleadings that you have said that the certified
Yes,
copy
yes,
was not filed. Where is that?
Paragraph 5, page 14.
Paragraph 5, page?
Page 14. Page 5, my lord, the petitioner upon instruction of the learned counsel.
Present status application for providing certified copies.
Certified copy of the trial court.
This is the application for certified copy of whom?
Or certified copy of the application number 2292.
That is whose application?
My applications, my lord. The
So
petitioner's judgment debtor's applications.
Yes, but they have filed the execution case.
Execution case.
So execution case they have filed along with the certified copy. So what's the difficulty?
The execution case, my lord.
Your case is that to you it has not been supplied.
Right.
So that's neither here nor there.
But
Yes.
draft, my lord, read, my lord, is verified to the, my lord, that.
It has been verified. That's the finding. If not, you have to apply there. Then file and review there. Go there, not here. Because
Then,
the
my
court
lord,
records, it is reported in writing that the draft read is without any error and there is no stay order as on
now,
date.
but my lord, record is that these are verified. Verified. My lord, what documents verified?
That you go there. For that I cannot. Ashun, this application under Article 227 of the Constitution of India.
separate. My lord,
What is the other matter?
other matter, my lord, I file an application my lord, challenging the order, the miscase on the ground, my lord, the previous advocate commissioner not to serve notice to all the defendants. My lord, this is the ground.
In the final degree proceedings? Take the no, oh.
The notice to the 1, 2, 3. Defendant number 1, 2, 3, they serve the notice only. on this.
You are appearing the other matter? Therefore, setting aside the final degree.
Paragraph 13, my lord, this is only that point. Paragraph 13, my lord, the
Paragraph 13
paragraph 13
of the order.
order.
What application was rejected? 151.
150.
Praying for setting aside of the final degree. The
Lord, takes up other matters, Lord, under compelling circumstances. Item number 54, my lord. The bank is taking possession.
The questions on this every day, even yesterday, during the middle of the session, my lord, they will give a notice, I will mention. And this is the notice. This
The
is
bank is
unbelievable.
Please wait. Yes, yes,
bank is
Father,
taking possession, my lord.
let them take possession.
And come back at 2, my lord. Can we come back at 2?
Let them take possession.
Even yesterday they did. Doesn't matter.
I didn't do this.
Your client, you are nobody. They Prabhu did
Yes,
that
yes.
yesterday. I can understand Prabhu doing it, not you.
Yes, scholar is not.
That the husband is the petitioner before your lordship, my lord, in a matrimonial suit which decreed ex parte after service of summons to my lord court bailiff in presence of
Suit. Wife's suit.
husband suit.
Husband's suit was decreed. Then
Then
why
my
the
lord,
husband is aggrieved?
then my lord, order 9 rule 13 proceeding has been initiated. The grounds under order 9 rule 13 is the non-service of summons. That's why he taken, my lord, the benefit of the Limitation Act. Your lordship knows if it is non-service of summons from the date of her knowledge, 30 days. Though, my lord, the application is expressly, my lord, time barred. But if the wife could able to prove with regard to, my lord, the non-service of summons, then the question of limitation will not arise. Kindly, my lord, I will, my lord, only place one portion of
What
the order
happened?
impugned.
Order
That has been allowed. Yes. Only on the ground, my lord, kindly takes up one portion of the order impugned here. My lord, kindly takes up, my lord, the second page of the impugned order before your lordship. It's the order dated 7th of May 2026.
7th of
May 2026.
Yes, second page.
Yes, second page, last paragraph, it's paragraph 1. This is the only reason, my lord, sole reason. With regard to service of summons, traversing the record, this court finds that as per the report of the Nazir, SD Civil Judge Junior Division Shialda dated 23rd of October 2017, summons was affixed in the main door in presence of two witnesses, namely Anjali Das and Anju Samant. After the petitioner refused to accept the same, though the said Anjali was produced as a witness by the opposite party, the witness, namely Anju Samanto, was not produced to depose as a witness. Perusing the evidence of Anjali Das goes to show that the petitioner have been able to shake the credibility of this instant witness, as during the cross-examination, she specifically deposed the belief did not call upon us to put our signatures, and I never signed on the document of the belief. No other independent witness was also produced by the opposite party in this regard. So, my lord, according to the learned judge, since one of the person witnesses who was present while the bailiff was executing, my lord, it was, my lord, given to her, she herself, my lord, refused, and thereafter it has been affixed. So, according to the learned judge, the requirement of law did not fulfill while the witness has not been signed. My lord, it is the Anjali whose, my lord, deposition is with me. She never said I have signed. She said that I was present over there, and her name has been taken place by the bailiff along with the another person's name. Kindly see, my lord, the requirement of law now. Order 5, Rule 70.
Where is the bailiff report?
Lord, bailiff report is not with me, Lord. That is from the court, but I cannot take out. Kindly takes up, Lord. That's the recording of the landed judge. I am taking it, Lord, as a true. Kindly takes up, Lord, Order 5, Rule 17.
You have a very bad case on merit, Mr.
No,
you are afraid of contesting.
No, Lord, it's a divorce granted way back in 2017. Lord, now
ex parte, please get it a contested.
It's not a charity also, my lord. I know, my lord, it's not that, my lord, she has a previous, my lord, incident with regard to 13B case also that was suppressed. There are many reasons.
So take all those points.
Lord, I am not on that. No, kindly takes up, my lord, Order 5, Rule 17 once. Where the, my lord, may I place? Where the defendant or his agent or other person as aforesaid refuses to sign the acknowledgement, or where the serving officer, after using all due and reasonable diligence, cannot find the defendant who is absent for his residence at the time when the service is sought to be effected on him at his residence, and there is no likelihood of being found at the residence within the reasonable time, and there is no agent empowered to accept the service of the summons on his behalf, nor any other person on whom service can be made, the serving officer shall affix a copy of the summons on the outer door and or some other conspicuous part of the house in which the defendant ordinarily resides or carries on business or personally work for them, and shall then return the original to the civil court from which it was issued, with the report endorsed thereon or annexed thereto, stating that he is so affix the copy, the circumstances under which he did so, and the name and address of the person by whom the house was identified and in whose presence the copy was affixed. So this is the requirement of law. The bailiff did exactly the same. She mentioned the name of the person in whose presence the entire act and deeds have been done. That person comes up in the dock and say, yes, it has happened in my presence. Now the learned judge is taking an additional burden, that as if when in cross-examination, she was stated that the bailiff did not ask her to put her signature. So the credibility of the witness has taken. But whether this is the requirement of law, Milord, may I ask this question to myself? And this is the only and sole ground, Milord, on which, Milord, the Order 9 Rule 13 proceeding has been allowed. And this lady has a previous act also in this nature. It's nothing but not to twist some twisting thing. Everything has been done after marriage, Milord, spending, Milord, much year back after.
What happened with the service with regard to the registered speed post?
That's the previous one. There are no observation with regard to that. Milord, Milord, your lordship knows, Milord, as per, Milord, the law, initial service summons has to be done, Milord, through post. And if it is not satisfactory, then the question of this, Milord, Order 5 Rule 70. So this, the learned judge is of the view, in view of only this portion, Order 5 Rule 17. Kindly see, Milord, comes back to the order impugned, Milord. I have not placed the entirety. The order starts, Milord, from second page, Milord, point number 1. I have already placed, Milord, the point number 1.
Person, Mr.
No, Milord, it's not a case of that also. The requirement of law is that in whose presence this has been done, his name and address has to be disclosed by the bailiff. That has been done. One of them comes to the dock.
These two persons.
These are two
Please show me the
persons.
bailiff report. Please show me the bailiff report.
is not with me, Milord.
Please
I
bring
cannot.
please bring the bailiff report.
That's
and
not
the
lordship has
evidence.
to ask from the Milord court. Milord,
Why?
Milord, bailiff's report I cannot obtain the
Certified copy, why cannot obtain?
certified copy.
Why you cannot obtain the certified copy?
Milord, very
In
well.
these matters, Mr. Mukherjee, you know,
Very well, Milord. If it is
bailiff
otherwise,
report,
sometimes, Milord,
evidence.
yes, very well, Milord. Milord, what I propose is, Milord, it's a 65 years old man. Kindly, Milord, see the agony of this man. This has been done way back in 2017. This, Milord, Milord, the wife wants to again reopen the entire issue, whether it's any or to benefit of anybody's. Now, Milord, the sole ground of this is, according to me, subject to my lord's approval, is divorce the law. Milord, it's not that the requirement of law suggests. Had it been a case that yes, the signature of those persons are the ingredients of Order 5 Rule 70, I bow down, Milord, I will go back. But if it is not, the learned judge cannot say this reason the bailiff went wrong, and my chief is also, this is, Milord, the Anjali's chief is also there, Milord. Kindly, Milord, I have taken that.
Chief will not help.
No, my lord, she has never even said that I signed. Had it been a case that witness volunteers that I signed as per the request of the bailiff over there, and subsequently, my lord, it is found in cross-examination she has not done that, then it could have been, even if it is not the requirement of law, but you have stated something which is not being proved at the time of cross-examination. It is not also that. I have, my lord, brought, my lord, the Anjali's, my lord, evidence in chief. Is my neighbor. In my absence, once, my lord, a ruckus being made by the wife along with her elder, my lord, sister. She and other, my lord, the neighbor has lodged a complaint, police complaint, that I have annexed. She is not, my lord, is falling from a heaven, my lord, and doing favor in my. It is not also that.
She is an interested witness. It appears from her chief.
My lord, interested, my lord, she comes and depose.
It's not so simple, Mr.
My lord, your lordship
It's
can
not so simple as that.
My lord, kindly, I have been an officer of the court, that's why I handed over the chief. My lord, I will bring the cross
After
also.
looking at the examination
Lord,
chief, Mr.
I can give your lordship the other, my lord, evidence also. My lord, she also, along with the other neighbor, lodged complaint, my lord, when the wife has created a ruckus, my lord, in the property in question, in my property in question, while the property was put into padlock. That's the incident reported before the police authority. I have annexed.
You have a very supportive neighbor, Mr. Mukherjee.
Lord,
you have a very supportive neighbor
today,
who comes
may I-
up to your aid,
may I ask this
lodges
question?
complaint.
So then, my lord, your lordship is disbelieving the belief. My lord, kindly, my lord, consider the aspect. The one
Not a
of the
question of
officer
believing and disbelieving.
My lord, the court
Mr.
is not gone
Mukherjee.
into that. The court has not gone into that. A 65 years old man again reopening the entire thing. My lord, only on this aspect, whether this will be any or to benefit of any other. Because my lord, today, even if my lord consider that an ex parte decree is being passed, there is out of that wedlock, my lord, no child begotten. Now today, the parties are living separately at least from 2017. Today, we are in 2026.
Those are on merits,
No,
Mr.
not
Mukherjee.
today. Not, what I am asking, the blood prejudice, not today the social stigma and all those blood has gone. She has a blood previous act with regard to 13B, previous marriage gone, suppression. I am not placing that. So this wife will not face any stigma. Everything boils down what? Money. Today also she can apply for that. But in a roundabout way, putting pressure upon the husband of 65 years old man to again fight it before a court, a battle, only on this score where the law is different. Kindly consider on that angle. Milord, it's my suit. Today, what I am on, it's my suit for divorce, which will be reopened. Milord, stay it for some time, examine it. But I shall place before your lordship the belief report also. Because it's an officer of the court who went there. Whoever is the neighbor who suggested, who identified the house, and whatever the requirement affixation at the time of affixation, she was present. And the witness also suggests that. So the learned judge went wrong, according to me, Milord, in my respectful submission, by saying that his signature is not there. She has somehow, Milord, in the cross-examination stated, Milord, she has rightly stated, she never signed. the requirement of law also doesn't suggest, my lord, she has to put a signature.
Ashu. Uh, huh? Returnable monthlies of September. Motion. Yes.
Lordship, I appear for the petitioner plaintiff landlord.
Yes.
Lordship, this civil revision has been preferred for partial modification of the order passed by the learned 6th bench presidency small causes court dated 2nd July 2026.
What is the modification which you want?
Lordship will kindly come to the impugned order. Lordship, the defendant, firstly, the defendant, after appearing in the suit, did not file any application under 7172. They directly preferred an application under Order 7, Rule 11, which has been rejected in this order. But in spite of that, from point number 13 onwards, the learned court, trial court invoked Order 14, Rule 2, directing the parties by framing preliminary issues for adjudication on maintainability point, in spite of the 711 being rejected. The defendant has no defense as no 7172 was preferred. In spite of that, the learned court has ordered that both parties are at liberty to adduce evidence on the preliminary issues.
Yes.
Lordship, no 7172 was filed, no rent has been deposited.
So what? Preliminary issues cannot be decided.
But Lordship, the defendant has no defense. Lordship,
He can adduce written statement not filed.
written statement is filed and accepted.
Then 7.3, has it been struck out?
7.3 is pending.
Then
my 7.3 is pending.
That has not been struck out as yet. That has not been struck out as yet.
But Lordship, the provisions of Section 7 is mandatory, which they have not filed. The defendants appeared in the suit in November 2025, and till today they have not preferred any application under Section 7172. To my eviction notice, they have filed a reply there too. They have given a reply. They have admitted me as their landlord. But in spite of that, they came up with an application under 711. Lordship, at one point they are claiming themselves to be a Thika tenant, one point they are claiming themselves to be a Bharatiya.
They are Thika tenant. This property is a Thika property.
But Lordship, they are not a Thika tenant. They are my tenant. They are my tenant.
Property is a Thika property. What's the status of your tenant? This property is a Thika property.
Lordship, but this is a Pakka property with RCC roof. It's a two-storied building.
Madam, this is a Thika property. From the reading of the plain, it's evident it's a Thika property.
But Lordship,
from the numbering, it's a Thika property.
Lordship,
your premises number is itself goes to show it's a Thika property.
But Lordship, there is a guideline that what is to be considered as a Thika property. My structure is a Pakka structure. It is a two-storied building.
Structure is also permissible.
It is a two-storied
2001
building.
Act under the Thika tenancy. So merely because it's that was under the 1981 Act, Kacha structure. So Pakka structure falls 2001 also Pakka structure has been brought within the ambit of this Thika tenancy.
But he has all along been paid rent to me, and before that to my mother.
Yes. So for that it does not become a premises tenant. It can be a Bharatiya also under the Thika tenancy act.
He is not a Bharatiya. He has.
That has to be decided.
Lordship, I have already.
That has to be decided.
Lordship will kindly come to page 26.
That has to be decided. And if they take this point, so they are not required to file 7172 also. They are not required to file. And the civil court do not have jurisdiction.
Lordship will
yes,
kindly
present
see.
suit is maintainable. The court has jurisdiction. All these issues are to be decided. This has to be decided.
Lordship will kindly come to the reply of the eviction notice, Lordship. Page 31.
So let them produce, let the court decide these issues. Let the court decide this. You have a very good case on merits. This after evidence, these points will be in your favor. Why try to stall that? So these points, if it is decided in your favor, they have not filed section 7172. So defense will be struck out. You will get a degree. No problem. So it's better for you. You should invite. Yes, please dispose of this so you can get a degree right now. You have a very good case on merits. Pakka property, Nokata Tika property, a very good case. So I'm directing these issues to be decided within a month. You get the
Lordship, the
property.
next date is fixed on Monday, 17th. And they have not filed any documents to show that
That's good for you.
they do not
Produce-
have any documents.
Yeah, so you will succeed in this. Where was their application under Order 711?
Yes, Your Lordship. Page 48.
Who are you? What is your name? How have you got the property?
Through inheritance from my mother.
What is the name of your mother?
Lordship, Charubala Dasi.
Ashun. This application under Article Yes, 18.
My lord,
This morning.
my lord, caveat was not served upon us, but since she has
Caveat noting is there, Mr. Banerjee.
caveat is,
Yes.
Also to them.
my lord, we have served them the copies.
Yes, sir.
We have served them.
What is this matter?
My lord, it is with regard to the visitation. My lord, we are suffering one habeas corpus order also, my lord. We shall habeas corpus order we have suffering.
Matrimonial proceeding?
Yes, my lord.
Guardianship?
No, my lord, custody.
Custody, yes.
My lord, the petitioner wife filed an application under section 24-25 of the Wards Act before the learned court below. My lord, in that the interim application has been filed by the husband with regard to visitation of the child. My lord, your lordship will kindly come to the prayer.
Yes, what happened to that?
Thereafter, my lord, your lordship will kindly come to the relevant portion of the order at page 81 of your
What is the order dated which you are challenging?
Yes,
81. No, what is the date of the order?
my lord, dated 5th June 2026.
5th June 2026. Yes, what is the problem with
Well, the
regard to this?
problem is, first is the physical visitation has been given.
Yes.
Second is, my lord, your lordship will kindly see paragraph number 12.
Yes.
My lord, digital and electronic access.
Yes.
From 7 to 7:30, which,
Yes.
my lord, the mother is a working lady. My lord, she is working in a, as a IBM, and over there the duty roster is very much irregular. My lord, the child is of 11 months. Secondly, my lord, your lordship will kindly.
How do you manage with the child then?
Well, there is one attendant. There is one attendant, and also her mother and
You are not
sister is
taking
there.
care of your child. You are so much busy in your work.
Well, work has to be done.
Yes, please do that work.
Well, work has to be done in relation to the maintenance of the
When
child.
do you return home?
Well, there was sometimes work from home. Sometimes it is work from
When
home.
you are working from home, there is no difficulty with regard to this digital access.
Well, digital access, 7 to 7:30 every day. Well, 11, what during the interregnum, what has happened? They filed a habeas corpus petition apprehending that I am taking the child outside the country. Well, during that time, the matter came up before the division bench. Well, over there, since we did not get any, we do not have any lawful order granting stay. The division bench directed us that a formal modalities has been worked out by which the visitation of the child can be worked out. Well, now during this time, the child is when the child is kept with the device, the child sometimes interferes with the device and tries to throw it away, or sometimes she becomes very much traumatized and comes out of the room. So this digital access, also, your lordship will also know that the rule committee of the Honorable Court has also framed some guidelines with regard to the manner in which the visitation and this other things can be worked out. This is the inconvenience. And the second issue is with regard to our objection. Why, in our written objection, we have stated that the opposite party husband from the beginning, from the birth of the child, had developed some animosity or some sort of aversion with regard to the girl child. For that, since the birth, when the wife was in their matrimonial home, he used to live in a separate room. Why? Because the crying, the taking care of the child was very much not in accordance with him. Later on, when he went for an outstation visit for around 2 months, I shifted to my own
Mr.
house.
Banerjee, it seems that your
What
allegation
has
is
happened?
against the husband.
What?
Forget about that, the relation husband and wife. Please consider the relation of father and mother. Please think in that angle. We are not deciding a matrimonial proceedings now. So please keep in mind the bondage between the father, child, and the mother. So don't keep those. The way you are arguing, it seems that you are arguing a matrimonial proceedings.
Well, over here,
allegations, you'll be making
they will
certain
be there.
allegations against the
Well, these are
husband.
the-
Husband will be making counter allegations against the wife. Please don't be swayed with that. Now we are concerned with the child,
the second,
father and mother.
Yes, ma'am.
So
The
the
one-
child, Mr. Banerjee, requires the attention of both. So these are the arrangements according to your work schedule. If you say some modifications, that can be considered. But if you say no, this should be stopped.
we are not. We are not.
Please, Mr. Banerjee, please give me a suggestion. So they have to consider what's the work schedule when you are working in home, no difficulty. So that can be sorted out. What's the schedule? Please give a suggestion to them.
Well,
They
let
can
us
also
come tomorrow.
consider.
Well, let us come tomorrow.
What is your suggestion, please? You are
Sunday at the Sunday.
Sunday evening, Bhalat, she is free.
Sunday evening. But this has been directed when?
Well, every day through virtual.
First and no.
First and third is before now to the DLSA.
So that you have no difficulty.
DLSA.
With police protection, no difficult.
Physical
police
A is not difficulty. So neutral
Provided there is
venue.
security.
And neutral venue. Please suggest
DLSA.
a neutral venue.
DLSA Barashat. DLSA Barashat.
Mr. Banerjee, do you think that that is a congenial atmosphere?
Yes,
DLSA
yes,
Barashat.
yes.
Apart from that, there are various neutral venues.
She's feeling uncomfortable, Malat. We had a talk with her. There are various issues, though we are not bringing it over here because one more which scars the mind of the mother was that when she had gone to her matrimonial home, I could not complete that. The husband
Forget
locked
about
the doors.
Mr. Banerjee. Forget about those. I think instead of DLSA conference room, some other neutral venue may be a better option.
Well, she is happy with DLSA because she is feeling secure.
You don't have any problem with regard to.
May I indicate, Lordship? Whatever has been stated is absolutely out.
Please don't go into that. I have not considered those. So Mr. Banerjee's client is present in court. That is why he is making those submissions. So it's a different thing. Now DLSA conference room is.
Problem.
All right. So let us proceed step by step. Then electronic digital access. Electronic digital access. Sunday you don't have any problem.
No problem.
And on other days you are saying work from home is there. So you get a schedule. How much days in advance with regard to your work schedule?
May I hand over the order that was passed in the habeas corpus?
Malat, over here, the work schedule which has been prescribed by her, she is dealing with foreign clients. Malat, she has to deal with, so there is erratic work schedule, but nevertheless, Malat, there is some difficulty with giving access to the.
After all, Mr. Banerjee, you are a mother.
Yes, Malat.
So you have to
Malat, we will.
So you have to spend some quality time with the child.
Always.
So out
Otherwise,
of that,
the child will not grow.
Yes. Out of that, please keep 30 minutes for the father. Because out of your quality time, please take out 30 minutes for the father. Please suggest which time on days when you return, what will be the convenient time. 30 minutes, you have to share the time well in advance. All right, come after 2. Please
2
take
PM,
instructions. Or when do you want to come back?
I am in some difficulty.
And next week I can keep it.
2 p.m.
2 p.m. Do one thing, she is not having, she have given a copy just now. She has also to please give your suggestions. What suggestions you have, please give it to her so that she can also consult with her client. With her client, if there is any suggestions, you can give it to her. She can come back. She can agree to that also. Please give a suggestion which is acceptable, because after all, you have to think the child also have to spend some quality time with
But electronically, quality time is creating some problematic situation with the child. Later on, it will transfer to some other avenues which we will have no other option to control.
He or she will not, Mr. Banerjee, he or she will not operate. He or she will operate through this when the mother is present. So mother will be in control. And nowadays, you must be having some personal experience also how the child nowadays is familiar with those electronic gadgets. So don't
Leading-
tell these things.
Leading
Don't
to
tell these things
psychological
that
issues.
he or she gets afraid.
My
Don't
lord-
tell these
my
things.
lord,
It's very
leading to
difficult to believe.
psychological issues that we are also
Because
suffering.
all of us are part of the modern
Yes,
society.
my lord.
So we know how this child reacts. So please give suggestions. I'm keeping it on Monday.
Monday.
With regard to there are three things. One is physical. There is no problem
issue.
with regard to both of you.
The
So no
electronic
difficulty.
access that we will
Electronic
have to work
access and other the birthday sometime.
Which I could not even place, Lordship. They have designed it so well, Lordship. They filed this application just one day prior to
Madam,
the birthday.
please think.
They have prevented me, Lordship. I could not meet my child.
That's a different
And
thing.
that is
Please
why you block the
don't
child.
bring your fighting as
Yes.
husband and wife.
Child is used
Please
as a pawn.
consider the welfare of the child,
Yes.
both of you.
Before writing.
Ashun, the learned advocate for the opposite party submit
As an officer of the court, my lord, this is my non-duty, my lord.
but
I
please
personally, my lord,
please ask Mr. Bhattacharya to join. Yes, what happened? 2 p.m.
item,
Yeah, please come.
item one. My lord, may I have an indulgence to mention item 137 will also fixed today, because tomorrow the matter fixed before the my lord court, that's a matter for transfer from section 24 applied in district judge. He has
But who
refused.
is appealing for the other side?
My lord, we have served it, my lord.
Then cannot be upgraded.
Kindly, my lord, tomorrow kindly fix it at the top, my lord, so that
Let me see how far I can proceed.
otherwise tomorrow 4 orders fixed before the my lord court bill, my lord, kindly appreciate.
Nothing will happen. Yes.
My lord, may I communicate on letter to them that the matter is.
That.
My lord observed that matter will be taken up.
No, I have not observed anything. This right, but yes.
The difficulty is, my lord, myself as well as my lord, Mr. Nag, both are my lord, not properly instructed.
Possession has been taken
on 1st of July. But my lord, the difficulty is application is still pending. I know, my lord, this is infructuous, and even if I have to file an application for restoration of the possession, that has to be filed before the trial court.
Mr. Bhattacharya, nothing. I think the order does not need to be modified because I've only directed. I've not stayed. I've not said anything. I've only said the application for stay is to be disposed of.
My lord, two things. First is, my lord, the interim order has been vacated. That has to be recorded. Number one, and number two, my lord, lordship has extended the interim order. That
No.
Initially, I said interim order is extended. Thereafter, I said on your prayer, you said no. I cannot make that. I've not extended. I've only said stay application to be disposed of.
Kindly record
prior to hearing of the appeal.
Yes,
my lord,
now the trial court will decide whether it's
Make out an application. Take out in the stay application. You can say these facts.
My lord,
in the written
my lord,
objection.
kindly, my lord, add one line that my submission is that possession has been taken, and the order has to be will go as it is. There will not be any problem. But one line submission has to be.
Mr. Bhattacharya, what is wrong in that? Because if that is the fact, I can only record.
One thing, let the matter appear tomorrow. I also have an application for expeditious disposal.
Of what?
Of that appeal.
That is also my lord pending.
Because, my lord,
here.
Yeah, before
Let
you
it appear.
No, both can, my lord, tomorrow both can appear, my lord, lordship can motive.
Kindly record his submission.
I'm recording your submission that you have taken possession.
On
What is the
1st of
item
July?
number?
Item number 12.
Item number 12 है ना? Yes.
For the plaintiff petitioner, my lord.
Yes.
The plaintiff in a suit for performance of a contract, my lord, of development agreements. But in such a suit, I filed an application, being a plaintiff, saying that it's a commercial dispute, it should be transferred to the commercial court. That was the sum and substance of that, my lord, that application. That application would, my lord, appear at page 58. In fact, what I wanted to say was, this court doesn't have jurisdiction, so it might go to some other court. Now, my lord, by the first impugned order, my lord, dated 5th of May 2025, the application has been rejected. The first impugned order is my rejection of my application. Then, my lord, I make an application of a recall that was also been rejected, my lord. That the second order is that order, my lord, of rejection of the application for recall. Now, my lord, the court says, since I have not prayed for return of the plaint, this application must be dismissed.
Yes. So, what prevented you from taking return of the plaint? Because is there any provision for transfer?
No, it's not there.
Then,
my lord, what I intended was this plaint ought to have been returned. But the court dismissed my application saying that I have not played for return. this was a summon substance of my application that primarily was written. Section 15 would not apply, stricto sensu.
Yes, that is what I'm saying.
Yes.
For during pendency, it could
Yes,
happen.
yes, absolutely. my lord. So the court says, I have not prayed for return of plaint for placing the same before appropriate authority.
So you have also not prayed for return of claim.
I have not.
So I record you, I give you liberty to file an application.
That's true. Now, my lord, kindly sees the second impugned order.
Yes.
Now, the second impugned order, my lord, it says that was, so I make an effort for recall. Second impugned order, my lord, is dated, my lord, 16th of December 2025.
Yes.
Now, my lord, kindly sees the order is the plaintiff is directed to make explanation as to why the suit shall not be dismissed for suppression of truth and imposes cost of 10,000. So, my lord, let this application of mine be treated, my lord, as one for return of plaint. That would suffice, my lord.
One thing, even if it is a commercial suit, if it is not beyond that limit.
So in that event, the court ought to have decided my application. It could have rejected my application on that score.
What is the valuation of the suit?
It's 63,000.
So it's not a, even if it is.
But, my lord, I would make an application before the court saying that it is a commercial dispute. My lord, and at the end of the day, I might have to give in to that.
Not commercial dispute. The valuation has to be
Yes,
enhanced.
yes, enhanced. My lord, but my application has been dismissed. That is the problem, my lord. He could have treated this application as one under Order 1 Rule 10 for return of plaint. He says that the appropriate remedy is Order 7 Rule 10. He says that. In the subsequent order, he says the court is not supposed to exercise inherent power to recall an order where the appropriate remedy is for return of plaint under Order 7 Rule 10. So he admits the fact. But he rejects my application just because it has been captioned as one under Section 15 of the Commercial Courts Act. Let him decide the application. But the court can also exercise such powers suo motu.
But Mr. Bordon, focus has not been directed. Though the court observed that why it should not be dismissed on the ground of suppression, but by this order you have not been focused for that.
No, but what my application has been dismissed. Section 15 application has been dismissed.
Section 15 dismissed. For that I can give you liberty to file an appropriate application for return of that.
But what happens to this, Miller? The plaintiff is to make an explanation as to why the suit shall not dismiss for suppression of truth.
But that's the in the body, but in the operating part, that
says hearing of maintenance of pecuniary jurisdiction. Last line.
So if you file an application for return,
well, he could very well treat this as an application for return. He could very well treat this application.
But you have not filed any application. You file an appropriate application for return. If that is filed, that will be considered in accordance with law. Otherwise, Mr. Bordon, this will be kept pending here. I can admit this.
I was just suggesting if I can serve and come back on any date, it will not take much time.
Mr. Bordon, it's difficult. Instead of that, what's the next date fixed?
I'll take instructions sometime next month.
So I'm directly giving you liberty. You can file that application in the meantime so that it can be posted. Where is the plaint?
The plaint is at page 18.
This application under Article 227 of the Constitution of India Yes, next.
In this matter, I am appearing for the petition revision. The matter relates to the perverse finding for the applications.
What is
Maintenance
the
penalty
impugn order?
like. The impugn order, my lord, is dated.
Enhancement of alimony pendentility.
Yes. Maintenance penalty without any evidence, my lord, because the evidence is not can.
You are for the husband.
I am the wife.
Wife. So you want further enhancement?
Further enhancement. 8,000 lordship, the 10 years ago, 8,000, and after 10 years, the after the car lordship, the only the 12,000, only 4,000 has been enhanced. Lordships and lordships, kindly see the husband is the chartered accountants, and lordships since 2011, lordships are going kana, going kana ki jani? Aditya Birla Groups, he joins 2011, and specific evidence is given by the employer, salary slips, everything, and 2 lakhs, 66,000 more, and now his lordship is earning the 3 lakhs, and we only 12,000. The lordship is order dated 14th November 2025 is the impugn order. The additional district judge, the Lanet Fast Track Court, Barashat met suit number. These suit lordships have filed the judicial separation under section 23 of the Special Marriage Act. Special Marriage Act. So lordship, kindly see this impugn order. তো পড়ছে এগুলো কি পড়ে নিচ্ছে আমার তো বলবে উনি বলেন আর বলে দিচ্ছি
$8,000 was fixed when?
It is 2016. Lordship, kindly
At that point of time, what was the income of the husband?
Income of the husband, lordship, is because
2,66,752.
2,66,000, probably since 2011 is joined the bar.
No, whatever it is, when 8,000 was passed, the income was 266,752.
Yes. I at that time I declare yes, my husband, because earning 1 lakhs, because I was not aware about the financial status of my husband.
No, the court found 2,66,000 was the income at that point.
Yes, yes.
So on that 8,000 was only given.
Only
Did you challenge that?
No, I'm not challenged because 35,000 at that time, lordships, I maintenance pending later. So lordships, only the 35,000, 8,000 was given at that time, not challenged, because I was not aware about the financial positions, financial status of my husband's.
Yes.
So the 2,60,000, 2021, I know from the employer's evidence. So lordship, after the summons, lordship, that evidence was shown, and that evidence was produced.
Is that the evidence stage? What is the stage now?
Stage evidence stage, because they did in lordship, the 2016, the Lanet Court.
Now what is the next date fixed in the matrimonial suit?
September probably.
For what?
For evidence. They didn't complete the evidence stage. So what I'll do, because they didn't complete.
Expediting the suit and directing the
lordship,
suit to be-
expedite this. In the meantime, lordship, the 12,000, it is possible, lordship, to maintain lordship, because
this application under Article 227 of the
So that time, the High Court, the bar, at the time of no maintenance penalty light. So Supreme Court says no. Maintenance penalty light is one of the application. When application was filed, certainly that should be disposed of rationally, reasonably. So, Lordships, it is a 20,000 rupees only. So 20,000, 25,000 and 2,66,000 salary. ড্রাফটিংটা ভালোই হয়েছে, ভালো ড্রাফটিং করেছে।
Yes, which paragraph of this judge you are trying to rely upon?
That the High Court, it is the main point is just civil সবই জানো, you know everything. Lordship, why you ask me? You know everything, Lordship.
No, which
Because
paragraph you are relying upon?
That judgment is, Lordship, High Court, Lordships, at the time, at this stage, on a High Court, Lordships impose the bar. At this stage, you will not get any maintenance amount, enhancement amount, certainly you will not be entitled. And at this stage, not. Complete the evidence stage, then trial stage incomplete, then after within 1 year, then Supreme Court says, Supreme Court view. কোথায় গেল আমার কাছে একটা জাজমেন্ট নেই, আর আমি তো রাখিনি রে কপিটা, দেখি দাঁড়া এই যে পেয়েছি দাঁড়া। Yes, Whitehead disposal, framing disposal with a direction not to praise the petition for enhancement of petition was set aside and maintenance increased to the 4,000 to 7,000 and also fixing the time frame of 1 year. That time frame for disposal of the main suit, but not, Lordships, not for praise the enhancement application. That judgment. প্যারাগ্রাফটা হচ্ছে প্যারা 6 and 7, না এটার সঙ্গে এটা মিলবে না।
Paragraph 6 and 7.
হ্যাঁ, প্যারাগ্রাফ 6 and 7.
Yes.
It is against the order of the High Court. Lordship knows, Lordship.
This application under Article 227 of the Constitution
That Chipra has been reported in 2009. I have given the citation. That Chipra has been reported in Supreme
My lord,
2009 in Supreme Court.
Bhattacharjee, ওটা reported in such and such.
Malad, in item number 1275 and 1276, Malad, the petitioner advocate, Malad, got an instruction. The petitioner advocate is having a fever.
I'm opposing because Malad,
He got drenched out in the rain, Malad. Altogether, a very high viral fever is there. Tomorrow it can be kept, Malad.
if tomorrow I don't have problem because suit for eviction of a licensee, suit decreed since 2024, Malad. The in the court below he is praying for time, Malad. Kindly see this last order that the revision is pending before the High Court.
What is the order and a challenge?
5,000 cost 5,000 Malad occupation charge has been directed to pay while granting the order of stay of suit in a suit for eviction of a licensee.
Yes. They have challenged that. Yes. What do you say?
But they have challenged.
What is the locality?
In Howrah, kindly see the impugned order.
Howrah, post locality.
Court observation finding is specifically that.
No, I'm asking you, you know everywhere in Howrah, is it a whether that in that locality 5,000 is the market rate or much less than that? You know it better, Mr. Mukherjee.
5,000 is less, but my client has not challenged. I cannot say anything.
Then yes.
Malad, it can be kept tomorrow, Malad.
So it has been
I got an
upgraded
instruction
upon
today.
mentioning.
Now only I got an instruction from the clerk, my lord. It is not that.
You are not appearing?
No, my lord, I am not appearing. He's a friend of mine, Animesh, that the clerk told me. He's having a very high fever. That's the reason. But tomorrow it can be kept, my lord.
The
kindly see this last order. Since 2024, it's happening, my lord. And this is the last order.
This matter was mentioned by the
Juniors, they have left out two other advocates.
suffer.
Malad,
Juniors,
Malad,
no.
Kindly be kept.
No, sir. Once you mention, it has to be
Malad,
alternative arrangement. 3 advocates represented.
Malad, everything will come out on me. I did not take out a.
No, sir. This is not done.
Malad,
yes.
And this is the last order.
Yes. What is this? Same.
Same. Order দেখাবে
Malad, Malad, a single day can be kept, Malad.
This is for the first time.
But this is for the first time, yes.
Malad, only I pray for a single day, Malad. This.
Call the juniors. If they come, yes. Otherwise, no. Either call them physically or ask them to appear virtually. Otherwise, no. I will take it up at 3 p.m. Ask them either to appear virtually or physically. The juniors. Yes. 3 p.m. Rakun.
I'll just have a talk with him.
Yes, call the next matter.
Preemptive petitioner.
Yes.
And the application for preemption was dismissed by the trial court, holding that the property has been partitioned.
That matter which you are mentioning.
Yes.
Yes.
Partitioned. They are neither co-sharer nor my lord the having adjoining land. Therefore, preemption was dismissed. Appeal court, my lord, has although considered section 2G26 of the Land Reforms Act that if the demarcated portion is transferred, in that event, my lord, preemption will not be maintained. They will not be treated. But my lord, court has recorded that since the registered deed has not been produced, therefore it is not partitioned. Therefore, they are co-sharers. My lord, page so far 2.6 consideration, my lord, page 6, paragraph 14.1, definition of co-sharer of
Page 6 of the appeal court.
appeal court.
Paragraph 14.1.
14.1.
Yes,
My lord,
definition considered.
considered, but at the time of my lord adjudication, taking decision, my lord, court has said that the property has not been partitioned because it was unpartitioned. Paragraph 19. No partition as per the West Bengal Land Reforms Act, paragraph 19.
Paragraph
19, page 8. It is clearly reflected that the fourth line, property was not partitioned as per the requirement of the West Bengal Land Reforms Act. That is section 14. On that ground, my lord, court has come to the conclusion that property has not been partitioned. Therefore, they are the co-sharers. They are entitled to get the partition.
Pond, how can it be partitioned, Mr.
My lord, pond is, my lord, in the online information. Online information, my lord.
What
court
is the
has-
description of the property?
My lord, it is Pukur Park, bank of the pond. My lord, I can show the partition deed, my lord, where from my lord you will get it. That
Why did not produce the partition deed?
My lord, it is exhibited document.
You said that the partition deed, there was no. In cross-examination, he has said DW1 found that no formal partition has occurred, nor has seen any deed or court degree relating to partition.
My lord, I do not know why this observation is there.
This
but
paragraph 17.
I have taken a ground that it was exhibit 2. Partition deed was marked as exhibit 2. And my lord, from the partition deed, my lord, it appears that it is pond and the bank of the pond. Pukur, my park. And court has said that online information was produced.
Exhibit 2 is the deed of partition. From where, Mr. Mahato, the trial court's order, please show me. Trial court's order, what is the finding with regard to this partition?
My lord, page 17 of the petition, point number 5, are the petitions are co-sharer of the plot land? My lord, it has come to the conclusion that they are not, petitioner are not the co-sharers. Page 19, the conclusion. Both the gift deed as well as the sale deed have been marked exhibit 3 and 4, respectively, from where it appears the petitioner are not co-sharers of the property. And exhibit 2, my lord, will find at page 2, page 18. The said partition deed has been duly marked as exhibit 2, from where it appears the partition took place along with the science. Page 18, middle. Exhibit 2.
Petitioner is directed to serve a copy of this application. I've said changing the name, not to change, not to.
Possession is my lord.
Where have you stated that they are proceeding with the execution? You have not stated, and your prayer is injunction. You have not stated anywhere. Yes, Mr. Mahato. You have not prayed that. I have allowed what you have prayed. What you have not prayed, that cannot be allowed. Yes, yes, call the next matter. Yes, who is appearing?
My lord, I have appeared.
Yes.
That on, my lord, the opposite party, my lord, executed a deed of gift. My lord. Thereafter, there was some problem between the donee and the donor, my lord, and they made application before the SDO, being the tribunal under the provisions of maintenance and welfare of
Senior citizen.
senior citizen. Right?
SDO did what? SDO passed what order?
That is page 28, my lord.
Page 28.
Cancel the deed, my lord.
Cancel the deed.
My lord. My lord.
Then what happened?
Then, my lord, they referred appeal before the appellate tribunal, that is district magistrate, my lord, and district magistrate, my lord, affirmed the order. But, my lord,
what is wrong in that?
Wrong in that, my lord, first of all, that is order of the subdivisional officer, my lord, no evidence has been taken, my lord, and even we are not allowed to file written objection, my lord, only on the basis of oral submissions. Our case was.
What written objection?
We are not allowed to file any written objection before the subdivisional officer. And, my lord, moreover, my lord.
That is the order of the subdivisional officer. Page.
Subdivisional officer, that is tribunal, my lord, page 28.
28.
Page 28. Annexed.
You have not paginated this.
So, my lord, there is irregularity in the pagination, my lord. Maybe. No reasoning, Lord. And there was no condition in the deed. My lord, we are the grand son and granddaughter, my lord.
You have not, before the appellate authority, you have not said that you are not allowed to file written objection. That's not your case before the appellate authority.
Mentioned. That is true, my lord, but there is no condition in the deed.
No, no, no.
That,
now you are taking, you cannot take that plea.
No, my lord.
Where is the gift deed? Where is the gift deed?
That is page starts 10, my lord. Page 10, the deed starts, my lord. We have developed the property, we have made construction, one street building on that property. And the opposite party is our grandfather, my lord. Now father has come, he left us, and now he has come, and our grandfather has become affectionate to his son now. He left a house, marrying second time. This is the problem. When father left us, we became helpless, my lord. At that time, grandfather is able-bodied man. He runs, he can fly a toto and earns sufficient money for maintenance.
Where is the undertaking that you have to maintain?
No, my lord,
The
there is
deed?
no undertaking in the deed. It was unconditional, my lord.
You have the Senior Citizen Act.
Yes.
Just give it to me.
As per the section 23, there must be some 23 subsection 1, my lord. There must be some conditions.
The learned advocate appearing for the petition. Just list this matter under the heading of motion to bolechi November. Yes, next.
The plaintiff Lord is the petitioner before your lordship. Now, for declaration, my lord, that the property in question is, my lord, of 5 decimals and not 2 decimals. Both
Declaration is 5, not 2.
Not 2.
You are the plaintiff.
I'm the plaintiff. The court has found prima facie case in my favor, but did not grant injunction.
Rightly so.
I'm sure, my lord.
That's not the only test.
But if I have a prima facie case, my lord, then in my respectful submission, others follow. Others come automatically. If I have a prima facie case, that's what 93 Supreme Court says. Thereafter, lots of people have tried to say a lot of other things, but that judgment has not been touched at all. And 88 Calcutta. These 2 judgments, my lord, on injunction have not been changed. And I pray before your lordship not to change it either. I pray, my lord, that your lordship does not change it either. Kindly have a look at the trial court's judgment, my lord. Page number 80, certified copy. the order dated is 31st January 2023. Looks to the last.
That's temporary.
Ad interim.
Ad interim.
Ad interim.
Mr. Chatterjee, I'm directing the temporary to be disposed of.
Sir, in the meantime, if they throw me out,
it's from 2023, you are without any interim order. So I'm directing.
During the pendency of that appeal, my lord, if I'm not mistaken, there was of the appeal. Lord, if I have a
That has
prima facie
also
case,
that has also stood vacated long back.
Lord, if I have a, Lord,
No, I do not know
it's not
what
my
happened in the meantime.
But I'm not paying for anything but status quo. Nothing beyond status quo. But my possession.
Status quo is a very vague thing.
My possession needs to be protected.
That
But
will
if
be maintained.
the business of the court, if it doesn't allow the matter to be taken up,
Mr.
not my
Chatterjee,
fault.
this is urgency. No, I'm not saying it's your
My
fault.
lord.
But the question is,
Sir,
at
23,
this
there
point
was
of
no
time,
stay, my lord. 23 to 26, there was no
the
stay.
next date fixed before the trial court for hearing of the temporary injunction application. Have you filed your?
I'm not me.
Yes, have they filed their?
Nothing. They have not done anything.
So I will direct if they do not file to hear out without the written objection.
Till that point of time protects me. It's not my fault. Have a look at it. Have a look at page 6, 31st January. Not my fault.
Mr. Chatterjee, from
Milan, I appreciate what falls from your
8
lordship.
months.
But may I ask this question to myself as well, my lord? From 23 to till today, the injunction has not been disposed of. That could have been done, has not been done. So it's not my fault that the process of the court takes time.
More than 8 months have passed from the refusal.
My lord, your lord, it's before your lordship for more than 8 months.
Chatterjee, I'm not disputing for a
It's not my fault.
It's not your fault. That's one way of looking at it. But now,
there can be very many, Milord. I might not have a prima facie case. Might not have a right. I understand. That is fine. But I can't be penalized because, Milord, the court can't take up my matter.
What is the next date fixed before the trial?
Milord, it was on the 6th, has been posted, Milord, after the pujas.
6th of
August.
After the pujas, when?
That we don't have instructions.
So I'm directing.
Milord, if kindly find, if I don't have a prima facie
They do
case,
not file the
throws me
written
out.
objection.
Milord, if I don't have a prima facie case, throws me out. But if I have one, kindly protect.
Yes, please show me.
Yes, Milord. Looks to the paragraph. This is the finding of the court.
Paragraph.
The last but one paragraph. Just above of the trial court.
Trial court.
Considering the case of the plaintiff along with the petition and the documents filed by the plaintiffs, though I find a prima facie case of the plaintiff, but right now I do not find any urgency. My property, I am saying that it is 5 decimals. The record of rights are wrong. I am showing it is 5 decimals. Court finds it. Still then doesn't grant me injunction. Milord, I ask this question to myself, is that fair?
Mr. Chatterjee, only thing was that you know very well consideration at the time of ad interim is urgency.
Yes. No, not just the urgency.
Yes, yes.
Just because it's urgent, Milord, that's why injunction will be granted. No.
No.
First is prima facie case.
Yes. But if satisfying all, if urgency is not satisfied, no urgency.
Milord,
no
it's been, if I am
Please
showing
show me
a
the plane.
yes.
Please show me the plane.
Kindly have a look at it. Kindly have a look at page 13 is the plane.
Yes.
Then kindly, the urgency, Milord, kindly turns to page 17 and sees paragraph 2.
What is page 17?
Is the injunction application.
Yes. Please.
Sees paragraph 2.
Please give me a minute.
I'm sorry.
Yes, page 17.
Yes, paragraph 2 and then 4. Every day they are coming into my premises. Look, this is a infringement which is happening every day. So urgency, my lord, is just because I've been able to prevent them today, it can't be, my lord, that I will prevent them from ever. And it is not in our latches, my lord, that we waited for the, my lord, for something. We've kept our mouth shut for something. We've always litigated. My prima facie case has been found. Even then, if the courts don't grant injunction, my lord, the litigants will go nowhere.
Where is that you have obtained an order of ad interim order in the miscellaneous appeal?
My lord, that is not here.
It's not
That
there.
is not here. That is not here. My lord, I'm
Now,
not that.
Yes,
Appreciate if I,
Mr. Chatterjee, from the filing of the suit till 2026, 3 years without
if
any
the
order.
courts don't take up the matters, my lord, it's not the fault of the litigant.
For that cannot be a ground for passing.
The ground is, my lord, my prima facie case.
This
The ground is prima facie case, nothing beyond.
this application under Article 227 of the Constitution
I had called by
as expeditiously as possible, but preferably within a period of 12 weeks from the next date fixed.
and I had called him, my lord. The file is also lying in the chamber and he is there in the doctor's chamber, my lord. I had called him, my lord. He's there in the doctor's chamber. It's not possible for him to get it on online, my lord. And the file is also lying in the chamber, my lord. The entire brief, my lord.
Mr. Mukherjee, what do you say?
What I will say.
Earlier matter?
If the matter goes down, my difficulty is that matter if the matter goes down to.
So I can upgrade it a little higher up, above in the High Court at Calcutta.
My difficulty is that matter they are showing the pendency and court is all granting time.
From the,
I am not on that. But if the matter is taken up, my lord, if the matter doesn't go down, I have no problem. If goes down, my lord, I have some problem.
One day
Eh,
will be also there.
no problem.
The 1275, the other one?
1275, 1276.
7576 কালকে রেখে ওইটাকে রিকল করে দিন। Yes, call the next matter. Not today করে রাখুন শুধু। On the prayer, not today করে রাখুন। On the prayer of the learned advocate for the petitioner দুটোতেই not today করে রাখুন। Mr. Mukherjee, learned advocate for the the client will know that you have done something, protected their interest. Yes, call the next matter.
That's my matter. I am at fault today.
What?
Pick it up Monday.
So Shanal, please start. Because adjournment, it goes down. That's the practice which I am following in upgraded matters. In upgraded matters, once you mention, you have to be ready.
No, I tried to be, but I could not.
Yes, what is this?
My lord, this is my lord. If
No caveat.
No caveat. No
Yes, what
caveat.
is this?
Caveat. I have served.
Yes.
I have served even. The difficulty, my lord, I mentioned because the next date was on 6th August. That's why I mentioned. This has been adjourned to some date in October.
Mr. Shanal, once it has upgraded, if it is not taken up, it will again go.
Again, I will mention it then.
Please start. Yes, what is this
একটু
matter?
মুশকিল হয়ে গেল দেখি কেন কিছু নেই
Yes, have you given notice to the other side?
No. That notice was not. Mention notice was given.
Mentioning
Mention
notice.
notice was given.
For upgradation, you have given notice. Yes.
Then
Yes, what is this matter?
after upgradation, I have not given.
No, not after. Prior to mentioning for upgradation, you have.
But a total dislodged today I am.
No, that you may not know. Your advocate on record would know whether prior to mentioning the notice was
No.
served.
That's given or
Yes.
not. I am.
That's given. You please start. Yes. What is this?
Startটা করব কি করে? I have missed it.
Mr. Sannal, I'm not giving.
I get your losses, man. I get your.
Please start. Please start. I can pass it over. You can go through my bail.
এই তো তাহলে হবে তাহলে
Oh, Mr. Mukherjee is assisting you.
হুম
Then there will be a running commentary. You can make out your case from there. Yes. Yes, Mr. Sannal.
আচ্ছা এটা ভলিউম কটা আছে জানো
তিনটে
অর্ডারটা কোথায় ভলিউম ইম্পিউ
Than you.
Of course, that should be man.
You will not be able to find out what.
Volume 3 টা দিয়েছি তো volume 3
independent suit for execution of the agreement, so specific performance of the agreement executed in between me and the other party.
Malad, this was a suit for declaration and permanent injunction
Yes.
for and in respect of certain agreement, all that.
In between me
In-
and
in-
the
In between myself and
the
the
defendant.
defendant.
in my suit.
In my suit. Now kindly see. Malad, considered thereafter, the petitioners is Tapan Kumar Mukherjee and Srimati Meenakshi Mukherjee filing the present petition under Order 1, Rule 10 of the CPC, read with Section 115 of the Civil Procedure Code, have stated that the petitioners filed a suit for declaration and permanent injunction against the plaintiffs of the instant suit and others. Malad, this is their suit they are speaking about. One, Minmoyi Rai, the predecessor in interest of the petitioner, during her lifetime was the owner of the premises, 58 by 1S Raja Dinendo Street, under PS Narkeldanga, Kolkata 6, now renumbered as 14 Dr. Bhupen Dotto Saroni, Calcutta 6, under PS Narkeldanga. Said Minmoyi Roy, along with her brother-in-law, Dr. H. N. Roy, instituted the Jane Roy Benefit Society, which had or he has hospital as well as nursery school in the premises as mentioned above. And the said society was registered under the Society Registration Act. As per rules and regulations of the said society, the certificate of registration of the said society is still valid and operative. The Jane Roy Hospital under the said society has 140 beds and serves the ailing patient at a very low cost. Such society has a board of trustees and Mr. Minmoy, Dr. H. N. Roy, Dr. Radha Binod were the trustee members and also the life members of the said society. Mrs. Minmoyi Roy during the lifetime executed a will in favor of the petitioners, by dint of which she bequeathed all her movable and immovable properties, including the property which is the subject matter of this section. But this is not correct. And appointed Keshav Chandra Basu and Tapan Kumar Mukherjee as executor of the said will. After demise of Minmoyi Roy, Shri Tapan Kumar Mukherjee applied probate of the said will, this is of Minmoyi Roy, and before the Honorable High Court, Calcutta, in probate case number such and such. And accordingly, on 9th February 1983, the Honorable High Court, Calcutta was pleased to grant probate regarding the said will of the deceased Minmoyi Roy. Since the death of Minmoyi Roy, the founder member of Jane Roy Benefit Society, the said society was running under the charge of the petitioner number 1, Shri Tapan Kumar Mukherjee, as a member of such society. As per contention of the petitioners, as per terms, memoranda, rules and regulations of the aforesaid society, only on the basis of the resolution by the life member and also the trustee members of the society, the trust would solve the terms and memorandum, rules, regulations of the society. The petitioners have further contended that the plaintiffs have filed the instant suit without impleading the petitioners as parties to the suit. This suit, although they are the necessary parties to
এটা
the
নয়
suit.
স্যার, আমি
This is
প্লেনটা
not. I will show
আমার
the plain.
প্লেটের শুধু
and-
প্রেয়ার দেখালেই হবে।
And the petitioners, therefore, by filing this petition, have prayed for necessary order to add them as defendants in the suit. The plaintiff has raised its objection by filing written objection. At the time of hearing, the learned advocate for the plaintiff submitted that the petitioners are strangers to the said suit property. And in collusion with the defendants, they have filed the instant petition in order to mislead the court and to delay the proceedings of this suit. The learned advocate for the plaintiff further submitted that one Mrs. Minmoyi Roy, since deceased, along with her brother-in-law, Dr. H. N. Roy, since deceased, and with 13 others constituted one society, namely Jane Roy Benefit Society, whose all members, whose all movable and immovable properties vested in the trust of the said society. And the members of the society became the trustees, who shall hold the office during their lifetime. And any vacant possession shall be made by resolution passed at a separate meeting of the foundation members and the life members to be called for that purpose. Minmoyi Roy was the first and the last secretary of the said society, who died on 6th September 1970 at the school building. According to her last will, she bequeathed all her properties in favor of one who is not her legally adopted son. In the said will, the land, building, assets, management of the hospital, I. Jitendranath Roy Shishu Seva Hospital, had not been bequeathed, and therefore
The petitioner cannot be the members of the Jane Roy Benefit Society. In the present suit, they are not the necessary parties. The plaintiff therefore has paid for rejection of the petition filed by the petitioners. The defendants also have filed written objection against this petition filed by the petitioners and have denied all the statements made by the petitioner in their petition. At the time of hearing, the learned advocate for the defendant submitted that the appellants have no right to file the present petition under Order 1, Rule 10 of the Civil Procedure Code, and the said petition is therefore not maintainable as per law.
আমি এবার আপনাকে একটু বলে দিচ্ছি দেখতে দেখতে আমার সুটে আমি যে ডিফেন্ডেন্ট বলেছি শোভনা তার সাথে আমার যে মৌটা হয়েছিল সেটার ক্যান্সেলেশন চেয়েছি যেটা আমার আমার মানে প্লেন্টিফের সাথে হয়েছিল জিতেন্দ্রনাথ রায় শিশু সেবা তাহলে আজকে আমার সুটে শুধুমাত্র সাবজেক্ট ম্যাটার হচ্ছে whether the mou entered into in between আমার সুটের কনস্পেক্টাসটা শুধুমাত্র আমার he can vent trust of the society against the defendants with regard to a memorandum of understanding. Yes. Cancellation of MOE. Yes. Now, what is the locus of the petitioner?
That's my point. He's not a necessary party to my
Sir, mouta dekhan sir.
Kindly have a
Where
look
is
at
this application under Order 1, Rule 10? Where is the application under Order 1, Rule 10?
Order 1, Rule 10.
এখানে আছে। First volume আছে।
Third volume.
First volume।
Just like this.
আমি বলে দিচ্ছি। So page 218.
218 second volume.
218. 218. আর স্যার মৌটা যদি দেখান
মৌটা আমি দেখো
হ্যাঁ
Mou will
103
and Mou your losses will get it 103.
at volume 1.
Let your losses place the 108, 218.
Petitioner filed another suit.
Yes. That's true.
Yes, that suit against the same defendant.
Against the,
no. Shobana Medical, no. Against
our suit against Shobana.
Yes, and this petitioner has filed another suit.
Yes.
Against whom?
Against not Shobana,
Not Shobana.
against the members.
Against what?
Against the members of
Against
our,
the members of our society.
by name.
By
not,
name.
Not by against my society.
By name against the members of the society, not against the society.
Do you have a plaint of
Copy
that,
of that
suit?
suit. That suit nahi. That suit.
What is the scope of that suit? What's the challenge in that suit?
সেই প্লেনটা নেই স্যার এখন আমার কাছে।
That plaint we do not have right now. In the application, first paragraph, second paragraph, your losses get it against whom they have filed it. Members of the society.
Ojol is also a party.
So individual.
Individual.
Now, MOU was for a development agreement or for development of a property.
For running the show, the
Shop.
hospital. For running of the
For
hospital.
running of the hospital. And one medical shop, I prefer.
We allowed them to run the show for the time being as per MOU.
The MOU is a part of your losses.
103.
103.
Volume 1.
That MOU we want to cancel. We have kind of declaration. Yes, MOU. Purpose of MOU, what is that?
Permitting them to run the hospital.
Permitting them to run the hospital. Permitting the defendant in my suit, Shobana. Yes. Shobana to run the business. I want cancellation. Because you don't have that capital and other things. Now I don't got that. The property which was the subject matter of will of Minmoy.
This is not
property which was the subject matter of will of Minmoy. Minmoy or what? Minmoy. What was the subject matter of that?
That's your loss.
Yes.
Kindly, we'll
The business was the subject matter also.
No, that's according to a no. Second volume will cover.
What was the subject matter?
Just I give you a loss with the rule. Sir, 260. And annexure A of the will your losses will get.
The assets, page 262.
As a page 260.
Immovable property, only this. Immovable property, column number 5, sir, 5A, only 19/4 Madan Mitra Lane, which is not the suit property.
Suit property is 58/1 as Raja Dinendra Street.
That is the property where the hospital is being run.
Exactly. That's the in my.
That was also the subject matter of the will.
No.
That property.
No.
Page 262.
262. Kindly look.
Immovable
of the property, immovable properties
column,
also.
Column number
5.
5A.
All that message, land heritage premises number 19/4 Madan Mitra.
Exactly.
Yes.
A suit property, malad, where we ask malad 58/1 is Raja Dinendra Street. That's the residential house of Minmoy Rai that has been given to that so-called adopted son.
And by showing this, they
wants to add to my suit
and enlarge the scope of the suit to be a complex suit of title.
Scope getting enlarged. What is saying? Scope getting enlarged by virtue of this addition.
সেটাই চাইবে the title
ultimately what he wants to be decided by adding himself a party.
Because privity of contract ওর সাথে নেই defendant এর। 5.5 বছর পর আমার ডিডাকশন অ্যাপ্লিকেশনটা দিব।
My lord, I cannot get my injunction petition heard.
Last 5.5 years.
Because this has been
One
done
after
for the
another.
last
One after another.
Initially, your lordships will find oral prayer was allowed without any application by the court below.
যেদিন ইনজাংশন শুনানি শেষ হয়েছে সেদিন on the day when the order will be passed on the injunction
On the day when the injunction petition hearing was completed, that was orally allowed. Then your lordship application came subsequently. All those orders are part of this petition.
This is to be heard at length.
But then your lordship pass an order of stay.
What stay?
Because
Stay of what?
adding, I can get my injunction petition out.
But
I have
clarify of what?
Asking me to add.
That cannot be stayed, Mr. Sannal, at the interim stage.
আমার amended
That will be allowed.
না না আমার amended claim ফাইল করছি না বলে
Injunction
ইনজাংশন শুনানি হচ্ছে
set aside.
এটা বলে দাও ক্ল্যারিফাই করে দাও
Then your losses clarify it. The injunction petition can be heard bereft of this order.
No,
because I have been
section,
directed to file
there is
amended
no
claim.
stay.
I have been directed to file amended claim.
Once I file that,
See the situation, my lord.
That you have to. But the injunction is against that party. What is the difficulty?
Can you clarify that?
Mr. Sannal, what is the difficulty in adding? It can be struck out after that.
but without prejudice.
So this application, where is the difficulty? We will be praying for injunction against the defendant.
Yes.
What is the difficulty which you will be facing? Have you filed an application for
First
injunction?
difficulty, someone poked his
তাহলে
nose in my suit.
আমাকে অ্যাড
That's
করে
a
দিলে পরে
different thing.
This
But
should not be
injunction application, any order has been passed, that injunction is adjourned.
hard
hard.
Then
Order not passed because of this.
because one party
One
added
came and asked for
The court-
addition.
and court
And then
directed
court
the
directed
amended claim.
that is that order, that for that order has not been passed.
No, that's not safe.
Then
order হার্ড ওয়ার্ক হয়ে গেছিল order আছে
if the matter has been heard, Mr. Sannal, I don't think you are better properly instructed. It cannot be a ground for not passing the orders.
That's to clarify that.
That's
Now,
the-
other difficulty or lawsuits, every possibility. According to us, the learned, the honorable judge, or learned judge has not been able to understand our case. Now, and that's our case. Maybe you're also accepting not. Now, when the injunction application will be heard, again, he will not confuse it. And will have to come up again with your lawsuit.
দেখেন স্যার পেজ 213টা দেখেন
213. All the orders have annexed.
ভলিউম 2
Volume
স্যার
2.
এখানে লিখছে today is fixed for reply to the argument of the defendant in respect of
Heard
the
Mr.
injunction
Sannal, learned senior
My lord, one prayer, my lord. My lord, one prayer before lordship rises, my lord. Item number 42 of today's list, my lord. Lordship heard this day before yesterday and kept it, my lord, for yesterday. But
yesterday, why did you not move that? There was
My
an
lord,
urgent bench.
no, my lord. Lordship
Was
kept it. Lordship, my lord, kindly, my lord. Tomorrow, my lord, kindly.